but the fates of some winners are still to be completely sealed. At least 400 National Assembly election petitions are still to be decided at different tribunals across the country, with some victories already upturned, I'm thinking Ugochinyere, by several tribunals. Now, in the same vein, some election results have been some election results have been affected by this tribunal. Some have been upheld, with the framework of the National Assembly expected to be affected at the end of the petition hearings and rulings. To whose feet do the blame of these many election petitions lie? 400 INEC political parties, or are you talking about the erring candidates? Or is it just democracy in action? Now, join us as we unpack this issue with our guest tonight. Barrister Victor Opatola is joining us from Abuja. He's a legal practitioner. Victor, thank you very much for your time.
Thank you very much for having me.
All right, let's zoom in straight to our first question tonight. Of course, we said, that we have so many of these cases. As far as you are concerned, what is the significance of the National Assembly Election Petitions Tribunal wrapping up their proceedings and preparing to deliver judgments for 400 election petitions? Victor.
The significance still shows that our election, post-election, is still heavily litigated. It still shows that the sportsmanship spirit in which ought to come alive in election is still no longer there. And most importantly, it still shows that there are a lot of details that ought to have been handled pre-election, which have not been handled, which has come to form the basis of post-election cases. Now, if you look at the trajectory of the of our previous post-election cases, and especially the recent tribunal judgment of the Presidential Election Tribunal judgment recently, it shows that a lot of these cases, a lot of issues that are made to come to bear post-election are issues that ought to have been trashed pre-election. So that comes to show that many of these issues that are raised post-election, many of them are issues that ought to be raised pre-election. And as it will be, as we will come to see, a lot of these cases will be thrown out for being frivolous, for being unmeritorious, because most of them will either be caught by being pre-election matter. Most of them will either be caught by time frame and a lot of other things. So, first of all, it shows that our election matters are still heavily litigated, and as much as it ought not to be, the judiciary, the court, will still be the one to determine most of who will come to be the governor, the House of Representatives, or people in the National Assembly.
Quite interesting. A cursory look, or the mathematics of this, or we talk about 400 cases at the petition. We have 109 seats at the Senate, the Nigerian Senate, what we call the Red Chamber. We have 360 seats at the House of Representatives, or the Green Chamber. We combine both of them, we have 469, which means there's only 69 National Assembly seats that are not in contention. Now, you've talked about some of them being frivolous, but it could be argued, Victor, that this is an indication that Nigeria's democracy is maturing.
Different strokes for different folks. Now, when we look at it, we can look at it from that angle, and we can also look at it from the angle that a lot of issues that ought to have been trashed pre-election, a lot of them are brought to post-election issues. This has very little to do with our democracy. Democracy is about, when we look at the democracy is more about the people, voting, exercising their franchise. Democracy has a lot to do with pre-voting stages, which comes to whether or not certain people can vote, whether or not certain people can vote using their temporary voters card. All these issues, majority of the bulk of the issue actually that are being discussed post-election are issues that ought to have been trashed at the pre-election stage. That is why I was saying earlier on that a lot of these cases will be thrown out for being frivolous, for lacking merit. Now, when we look at other climes, other climes who practice democracy the way it ought to be practiced, we will see that a lot of them do not deal with post-election cases. The majority of what they deal with, most often than not, are pre-election cases. That is why in America you will hear people going to court to determine whether some persons can vote by mail, whether the vote that ought to be done, whether a candidate is a citizen of the country or not. So majority of these things are what are dealt with pre-election, and it has very little to do with our democracy.
All right, it has very little to do with our democracy, you see. Quite interesting take there. Let's look at the fact that some of the aggrieved candidates withdrew their petitions. These are aggrieved candidates who went to court, who spent money, hired lawyers, and at some point they withdrew their election petitions. What do you think could be the reason or reasons behind such action?
There are numerous reasons, actually. It can be political considerations. It can be pursuant to advice of their lawyers. It can be due to so many things. It can be due to the paucity of evidence. It can be due to so many other considerations, even a lot of them that we personally cannot envisage. So it is not fixed. It can be it can be to duress. That is also one of the issues that can lead to people withdrawing their election petitions in court.
All right, very interesting. Barrister, how do you think the outcome or the outcomes of these judgments for the National Assembly election petitions will impact the political landscape in Nigeria, particularly at the national level, with regard to federal lawmakers whose fates are at stake? We have some of these lawmakers already chairmen of certain committees in the National Assembly. Some are members of committees. Some have already started the work, and they've gone to an extent. I remember the last Senate President, Ahmed Lawan, he lamented. What was his lamentation about? He said, well, many of those who were in the last National Assembly lost the election, and you had a slew of fresh faces come in, and that Nigeria had lost a huge chunk of people with legislative experience, and it's almost like starting from square one. Well, some of these guys have been taken through, the trainings and all that, and they're being asked to go home. Yes. So what impact do you think, or the implication do you think this will have for Nigeria's political landscape at a national level?
Well, the first thing, it makes the political landscape unstable. That's the first thing. Now, it has come to light that we need to amend our laws to ensure that post-election cases are determined before political officers are sworn into office. Our laws need to be amended to ensure that post-election cases are determined before political actors are sworn into office, or before they start or commence the functionality of their office. Now, it is still uncertain. A lot of people, even these people in the National Assembly, they will be subject to imbalance, as the case may be. They will not be focused on the work which they ought to do, at the National Assembly, because their attention will be divided, their resources will be divided. So the solution here is to amend our laws to be in such a way that political actors, post-election cases are determined well enough before political actors take office.
Very interesting. Almost like what some have suggested for the presidential election, that before any president should be sworn in, all the court processes, all the way to the highest court, the court of last appeal, all of it should be done, concluded and dusted with before the president is sworn in. I'm sure the similar thing you're suggesting.
Yes, that is exactly what it is that I'm saying. And apart from that too, the burden of proof, the presumption of regularity that is placed on INEC ought to be amended to. INEC should be made to prove the result that they've given to the citizens of Nigeria. So, presently as it is right now, there's a presumption of regularity in favor of any election that that INEC presents. That means candidates will have to fight an uphill battle against such presumption. So those are some of the amendments that need to be done, against any future election.
Victor, what are the potential implications for the candidates, their political parties, even their constituents, where these judgments will be delivered?
Well, like I said earlier, it's pure instability, uncertainty. That is the consequence, and it actually breeds one of the problem. Okay, one of the resultant effects where the judges are made to take up the role of citizen and decide who become the governor, who become the president, is that it's one way or the other gradually begins to erode trust, especially in a setting where the judiciary, the trust that is placed on the judiciary is minimal, as the case may be. So one of what we have come to see over the time is that it breeds instability, it breeds uncertainty on the part of the electorate, on the part of whoever it is that is actually holding office currently, and a lot of expenses, resources is put into this effort. So basically, what it breeds is instability.
Quite interesting. I want us to look at the judiciary. These guys who are on the bench have not been given some space to breathe in recent days. I'm sure you know why. But let's spare a thought, Victor, for our members, the honorable learned justices of the bench in Nigeria. What do you think the complexities are for these guys, who are sitting on these cases? Can you give us some insight into the challenges and complexities faced by these National Assembly election petition tribunals handling such a large number of cases within a relatively short time?
One of the complexity is time. Time, actually, that's the first thing. And the second thing is that currently we have a lot of people who are focusing on the judicial process of post-election cases. And one of the challenge is that a lot of people do not understand the process of how law and evidentiary process, how it works, how the intertwined system of law and evidence, how it works. A lot of people do not understand it. So most often than not, the judiciary is easily brandished, in a negative light. And apart from that, our laws are not exact, are not certain. Another problem that the judiciary faces is that expectations of the citizens are so heightened against the whatever evidence it is that is presented in court. And most especially politicians, as the case may be, they tend to sometimes overeat the polity, and all this burden is actually placed on the judiciary. So those are some of the problems that the judiciary encounter.
Yeah, I mean, Victor, we had a chance to see what the judges go through. When I heard we sat through the judgment, I said, my God, so it was a human being who sat down to write all these things, 14 hours. That was a lot. So I think they go through a lot. I don't know if judges still write with the hand, but another stakeholder or group that also has not had some space to breathe, maybe we'll help them breathe today on this program, is the Independent National Electoral Commission. When it comes to electoral offenses where petitions and all that, INEC at some point in time, I think it was the national chairman, one of the past national chairmen, said, guys, we need to have an electoral offenses commission to deal with the courts so that we, INEC, can focus on elections, and that they were inundated with court cases. And you look at the budget of INEC, there was an argument that they spent too much on litigation. Let's help INEC breathe a bit tonight on the program. What are your thoughts on what INEC goes through because of the large volume of these petitions from National Assembly elections?
Definitely, INEC has a lot of cases on their hands, but a lot of these cases can be done away with by simple regulatory procedure. By simple regulatory procedure, a lot of these cases can be done away with. Going by the pre-election procedure, INEC has not been effective, in the when it comes to the use of administrative law. INEC has not been so effective. For instance, now, INEC ought to have powers to determine eligibility of candidates, to determine whether or not a candidate has presented the minimum requirement of the law. Now, for instance, now, if the Electoral Act gives INEC the powers to monitor primaries. So if a particular primary is not conducted according to the guideline, according to the Electoral Act, INEC has the power to determine that. That is administrative law procedure. If a candidate is supposed to submit certain document and such candidate did not submit it, INEC has the power to declare that such candidate cannot contest for election so far he did not submit the required document within the time frame stipulated for such document to be required. It is now left for the candidate to go for judicial review. So by doing all these things, by making effective use of administrative law procedure, it will definitely reduce the rates, the numbers of election, post-election cases that INEC has to handle. And most importantly, like I said earlier on, we need to effectively work on our laws to make sure that the cases that, I said earlier on, that a lot of these cases that are in court currently, a lot of them will be thrown out for being non-meritorious, for being frivolous. A lot of them will be caught within time frame and time limit. A lot of them will be caught in between the law. So what it is that I'm saying, in the basics of what I'm saying, is that we need to make our law all-encompassing in such a way that cases that we proceed to post-election court cases will be so streamlined that it will be only for some particular cases or for some particular issues that can go to court as post-election cases. This will first of all reduce the burden of the judges. It will reduce, the huge amount of money that goes into litigating a lot of these post-election cases.
All right, Victor, we've seen quite a different, judgments, different decisions being taken by these petition tribunals in different states on the same National Assembly issues. And for some of us who are laymen, not learned people like you, we wonder why we have, for the same National Assembly elections, though in different parts of the country, we're having different sort of decisions. For instance, in one of the popular cases in Imo State, whilst the court upturned the election and ordered a fresh election, the tribunal said the winner of that election, who represents PDP in Imo State, cannot participate in the fresh election that will be conducted. In another part of the country, in Delta State, for instance, a senator is facing a rerun. He will be part of that election. So what do you think goes into the mind of the panel of judges when they stop a particular a candidate from contesting the rerun in one part of the country, but another part of the country, so you can be part of it? What goes on? What's happening?
First of all, some of these cases have gotten judicial imprimatur of the Supreme Court. Meanwhile, some of them have not gotten. But for those that have gotten judicial imprimatur of the Supreme Court, there's a burden on, the lower court to follow judicial precedent of the Supreme Court. But be that as it may, a lot of these cases on the superficial level, have semblance. But lawyers, in their ingenuity, we have a way of distinguishing some of these cases, to show that, they are not exactly the same. They might appear to be the same, but, the instance, the circumstance, and the application of the law, does not correspond, are not the same in both cases. So some of these cases, the lawyers, successfully distinguish, the difference in some of these cases. Meanwhile, while in some, it's just a matter of perspective, judicial perspective, depending on who and who are sitting on the panel, on the judicial panel. So this will always happen unless in cases that a superior court has given a position. This will continue to happen unless in cases where the lawyers have been able to distinguish the fact and law in these two instances. So, like I said, I just mentioned two reasons why some of these things happen. It will continue to happen unless, in that particular situation, a superior court of record has been able to give a superior judicial precedent on that matter, which the lower court are bound to follow. In some of these instances, irrespective of the fact that the superior court has been able to give, a definite judicial precedent on this matter, sometimes the lawyers successfully distinguish between the issues. So, those are one of the reasons why circumstances like this happen. And it does not mean that, the judges are giving contradictory judgment.
All right, Victor, I'm going to push you back to the wall a bit, and say as a layman that I'm still seeing some contradictory pronouncements. Now, all right, I'm still seeing some contradictory pronouncements. For instance, at the Court of Appeal, Presidential Election Petitions Court, holding at the Court of Appeal in Abuja, what the panel of justices said was some matters were pre-election matters. They were affairs of the party, internal party matters that should be for party members. Yeah, you remember that. But I want to take an example very quickly. In Lagos State, Shomi of Labour Party lost his seat as House of Reps member for Ojo federal constituency. The tribunal declared the APC candidate winner, duly elected, based on the grounds that Shomi was not duly sponsored and qualified to contest. Sponsored. Now, is that not an internal party matter that should have been settled before the election? Okay. Just like this,
I'm finding it difficult hearing you.
Sorry?
I'm finding it difficult hearing you.
Okay. I don't know if we have the time to take a repeat. We don't have the time. We have to leave it at this for now. We shall have the time to have you answer this question. But Victor, thank you very much for joining us tonight on Politics HQ. We will be watching the space to see what happens if they go for appeal, some of these 400 National Assembly members. Thank you for your time.
Thank you.
Right, we'll take a short break, but I guess on the first segment was Victor Okpatola, a lawyer who joined us from Abuja. We'll be right back.